Oh, hello, hello. Welcome back to my channel. I know it's been a while since you guys saw me on a live stream, so I hope you get notifications for this. But yeah, I can see some people in the comments already. Thank you for joining. Thank you for waiting for this session. If you're new to my channel, my name is Faye Mac. I post videos about life in Canada and how to thrive in Canada. So, yeah, in today's video, I'm bringing you something very good. It's about wills and estates here in Canada. I know that a lot of us probably have knowledge about this from Nigeria or our home countries, but this time I'm bringing you information about wills in Canada and why it's important for you to have a will here in Canada, not just in your home country. And today I have a special guest of honor. I'm sure you must have seen on the thumbnail. I have an amazing guest, and I'm just going to add him to the stream now. While I'm doing that, please drop in the comments what city or country you're joining us from. We'd love to see where everybody's from. Drop in in the comments. Comment from Ghana. Hi, very nice to be on here with you. Okay, there's Daniel, our guest for today. Hi, Daniel. Welcome.
Thank you very much. Thanks for
You're
having me.
welcome. Thank you for joining. I know you're a very busy man, so thank you for taking time out of your schedule to join us today.
Absolutely. I'm happy to be here. It's an important
Great.
topic.
It is, yes, especially for our community too. But just a brief introduction. I'll let Daniel do the honors of introducing himself.
Sure. Yeah. So, hi, everybody. I'm Daniel. I'm the co founder and CEO at Epilogue Wills, which is a Toronto based company that helps people create wills and other estate planning documents online. So, my personal background is before starting the company, I was a lawyer practicing in Toronto doing corporate tax and estate planning work. So, it's an area that I am familiar with. And in practicing, I saw how difficult it can be for people to get these important documents done. And so ultimately, that made me want to create a solution that would make this easier for people, easier, more affordable, and more accessible.
That's awesome. And I'm glad that you mentioned that were you a lawyer or are you a lawyer? Like
Yeah,
still
yeah,
licensed to practice? Do you
yeah.
still practice?
I don't practice anymore. So
Okay.
I've changed my status. So I'm still a lawyer, but I'm not practicing as a lawyer. This is my full time. Yeah.
Nice. Nice. So co-founder of Epilogue Wills. I know you give a quick blurb about what Epilogue Wills does, but can you tell us a bit more about, the organization? How did you come up with the idea of, bringing wills in such a convenient way? How was that like?
Sure, absolutely. So, yeah, as I mentioned, I was practicing in this area. So, I was helping people make wills. And the firm that I was at was mostly geared towards high net worth and ultra high net worth clients. But I would also be asked by friends and family and colleagues if I could help them with their wills. People who were recently married or just had kids or just bought a house. And I knew that the rates that I was charging at the firm were high, and we were bringing a lot of value to a lot of the clients of the firm. But when I was doing something that was more basic and still charging at what my rates were, there was a little bit of a disconnect. So someone who was looking for pretty basic planning, leaving things to a spouse or equally to children, who was just looking to name a guardian for minor children, those people weren't getting the full value out of sort of what my rate would have been. So we thought that if we could simplify the process, bring it online, make it easier for people to navigate, make it more affordable, that we could help people to actually do it. So we started in the middle of 2019. We launched in March of 2020 in Ontario, and then we grew the company and expanded across the country. So we're now in 9 provinces. We're not in Quebec and we're not in the territories, but we're everywhere else. The website is epiloguewills.com. And when someone goes there, they can click Start My Will in the corner, and it will just take you through a series of questions, single questions, single answer, to help someone sort of understand what they're doing and make their way through. And then at the end of the process, their documents get created.
Wow, that's amazing. And I'm happy that you mentioned that, while you were practicing, the rates were, of course, high because you're a lawyer, right? Like the rates are high, you're charging lawyer fees, but there are certain services that the ordinary person wants that are just basic, not the entire works. And, you were able to bring that at a more affordable rate for the people. So that's awesome. Well
Thank
done
you.
on that. Yeah, I like that. I like that because a lot of people don't think that way, right? They just want to make the money, but you're bringing solutions to, help a wider range of people that probably also, just don't want to go into a lawyer's office and, have that entire experience being in a lawyer's office. I know that it can be tedious setting up a will, so simplifying that process definitely makes a big difference.
Yeah, absolutely. And
So,
a
yeah.
lot of the people that would have sort of used the services of the law firm, this product, this solution might not be a good fit for them. So they might continue to go to lawyers and get their wills done, and that might be the right thing for them. And as you said, the idea here is that right now about 50% of the Canadian population, 50% of Canadian adults don't have wills. So there's a lot of people who are doing nothing, right?
Wow.
They're not going to lawyers. They're not getting it done at all. So this really is a solution designed to help sort of introduce people to estate planning in a way that's more accessible and more affordable, in the hopes that we can get people to actually get these documents created.
Awesome. And other than the process and the cost, what is the difference between having a will through Epilogue versus having a traditional will?
So the document will be largely the same. So what makes a will legal is not that it was drafted by a lawyer. What makes it legal in the sense that it's legally binding is that it's been signed properly. And so if you get a will done with a lawyer, the advantage there is you're getting legal advice. So Epilogue Wills is not a law firm, and you're not getting legal advice. You're getting legal information, and you're getting access to a platform that will help you navigate the process, but it's not legal advice. So for someone whose situation is complicated or unusual, maybe that's a place where working with a lawyer to get specific legal advice can be really important. But for someone who is going through, who is looking for basic estate planning, the actual document that you would get from Epilogue is not going to be all that different from the document that I may have drafted for that person if they came into my office when I was practicing.
Right, gotcha. So at the end of the day, the actual document is what really carries the weight, not really the process in which it was obtained.
Yeah, there's no distinction between like a lawyer will and an online will. They're not different kinds of wills. There's only one, like there's the will. Anytime a will is typed and printed, it's the same kind of will. Um, and so, yeah, the difference is more whether you got legal advice in the preparation of it. But once those documents have been signed, whether it was done by a lawyer or done using an online system, they're the same type of will at the end of the day.
Nice. That's very good to know. Let's take it back to the basics a little bit. Um, why is a will important? So for someone like me who is, not even 30 yet, I have a kid and a husband, but I'm not a millionaire, I'm not a billionaire. Why do I need a will?
A couple reasons. So a will is the only legally binding way to set out what should happen after you're gone. And so some of that is about assets and things, and some of that is about relationships and people. So as you mentioned, if you have a child, a will is the only place to name a guardian for that child. So if it is the case that when, and I won't use you, when someone passes away, if they were the only guardian at that time or the last living guardian of a child, then determining who should become the guardian going forward is something that is going to be dictated in the will. Provinces across the country have slightly different regimes, but ultimately in all those places, you're going to name a guardian in the will, and that is going to carry some weight. In addition to guardianship, so the distribution of assets. So if someone doesn't have a will at all, then the way your assets get distributed are based on the rules in your province. And so in some cases, it might mean that everything goes to your spouse, which might be what somebody wanted. But in Ontario, for example, it can be a split between your spouse and your child. And that might not be what somebody wants if you've got a very young child that sort of immediately they would have some type of entitlement. And so for distribution of assets, the only way to decide what happens and not leave it up to the province is to make a will and have those decisions recorded. And there's others as well, but those are the first two that come to mind.
Yeah, that is very critical to note, especially as newcomers to Canada or immigrants who, back home, if somebody passed, I feel like if they didn't have a will, there's a lot of family and community to help with the kids, and we see that play out a lot back home. But here, where you're new and you might not have family or friends here, being in control of that decision of what happens to your kids after one passes is very, very critical. Like, it cannot be overemphasized. So, thank you for pointing that out. Okay, so what are the factors that a person should consider when creating a will? And I noticed you didn't use me in your example. Thank you, because I'm Nigerian and we don't play like that. So thank you for that sensitivity.
Absolutely.
But yeah, what are some of the important things? I know you've mentioned, your child, well, a person's child, and what happens to them afterwards. But what are some of the other things that make it important that you should consider when you're creating a will?
For sure. So I'm gonna talk about three, and then I'll go through each. So one is, as I mentioned, guardianship. Number two is distribution, and number three is executor. So let's start with guardianship. So if you have minor children or pets, a will is a place where you can say who you want to be in charge of them when you're gone. So that is critical. That's a big motivator for a lot of people to make a will, is having kids and wanting to name guardians. It's challenging for sure when it's actually time to sit down and write it and make that decision about who you think is the right person for the job. It's also a place that trips a lot of people up, and maybe they start the will to name a guardian, but they stop because they can't make a decision. But guardianship is one of the big ones. The next one is distribution. So who you want to get your stuff. So in some cases, it's very simple. If someone is, for example, married with no kids, it might be that their spouse is going to get everything, and there's not too much thinking or consideration to be done there. But then there's also alternate distribution. So if the person that you want to get your stuff in this example isn't alive, then who would you want? Is it children? Is it siblings? Is it parents? Is it cousins? Who's it going to be? So when someone makes their will, they should think through some of those things. Who do I want? Is it going to be one person that gets everything? Am I going to split it a certain way? That decision might be different if someone is unmarried, single, in terms of who that first person is going to be. So distribution is important. And then the final one is executor. So who's going to be in charge of managing the process? That's a very big job as well. And so deciding who that person is going to be, who's going to have that responsibility of making sure that everything gets taken care of according to the will. That's the third thing that people should think about beforehand. So if you have minor children or pets, who would you want to be in charge? When it comes to your stuff, what would you like to happen with it? And then finally, executor, who do you want to put in charge?
Right. Okay, I'm gonna ask you a little bit about the executor, because I worked in a bank for a few years, and I would be in that process of if a client dies and the executor of the will comes in, and with probate and everything. What is really the responsibility? Like, what is the magnitude of the responsibility of an executor of a will, and how does RBC come in to that?
Sure. So the short answer is it's big in terms of the role and the job. There's a lot of different tasks that you need to do as the executor. In some case, you're working with the courts, like obtaining probate, which we can talk about a little bit more, working with the bank, setting up new accounts, working with the beneficiaries, working with the government if there's things that need to be filed, tax returns and planning funerals. So it is a big job, there's no doubt. When it comes to naming an executor, you can either name a person to be an executor, or you can name a professional trust company. Those are sort of the two different options that are there. So for a person, you could name a spouse, you could name a friend, you could name a sibling. And when it comes to a professional trust company, there's a number of them. We work with RBC. And so RBC, the bank, owns RBC Royal Trust. And there they have it's a trust company. And you could name them in a will. And then after someone passes away, it is a trust officer at the trust company who is actually responsible for all of those things that I mentioned, all those different tasks. When it comes to that decision about whether to name a person or to name a trust company, one of the factors that people consider is cost. So if you name a person, that person can claim compensation. They can be paid for doing the work. They might not, but they can. When it comes to naming a professional trust company, they will be compensated. It's a guarantee. So you actually sign a fee agreement right away. You sign a fee agreement when you complete your will, which sets out what the fees are going to be. So you get the benefit of having a professional in that role, someone who knows exactly what they're doing, someone who will be there, right? Like if you name an individual, that person might not be in the country anymore. They might not be capable anymore. They might not be alive anymore. So it's a trade-off. So it's one of those things that, as I mentioned with executor, is important to consider who would be right for the job. If someone knows someone who's very responsible and who they think would be able to handle the role, and in some cases, let's say it's a spousal relationship and your spouse is going to be getting everything, and you also think that they could handle the responsibility of being in charge, that might make sense. So lots of different things to consider when it comes to the executor.
Right. And I want to emphasize this because, like I said, I worked in a bank and I've seen some very messy situations with trying to, get money and all of those through the will. So if it makes sense that you're working with RBC on this, it just makes sense, and especially for our community too. Like I said before, a lot of people don't really have family in the country, and if they do, they might not even be in the same province. So, and at the end of the day, you might have family here, but are they capable of being the executor of the will? And do you trust them to be able to execute your will? I've seen a situation where, like you mentioned, you can have an executor and then that person is just not capable. I've seen a situation where the executor of a will had passed. And so they had to go, like, it was like a second executor listed or something. And even that person had passed.
Mm-hmm.
So, yeah, it became a huge mess. And so having a large corporation like RBC be in charge of that execution, I think is just genius. So I really like that idea. I like that you have them on board. And my next question is about properties abroad. So a lot of us, watching this live are skilled professionals that came to Canada with, skills and assets already existing. What would you say about people who have multiple properties or even one property in a different country or multiple properties in multiple countries? Does this Canadian will cover their properties abroad, or does it only cover properties in Canada? Or does it only cover properties in their province? How does that work?
Good question. So I should say I can't give any legal advice, but your Canadian will, the will that you create in that province, is intended to cover your worldwide assets. Now, having said that, there can be challenges with the laws in different countries. So we ask a question in our process that says, do you own real estate outside of Canada? And if the answer to that is yes, we message to that person that says, if you have assets in Canada and relationships in Canada, you'll need one here too. But you should learn about what the laws are in the country or in the place where your other assets are, because it might be very challenging to get a court in another country to recognize your Canadian will. So for someone who has assets or has real estate in another country, I would recommend that they speak to a lawyer in that country to understand what happens between multiple wills, to learn, okay, so if I have a will in Ontario and I have a will in this country, how do these two things work together? So if you have assets here, then you'll definitely want to have a will here as well. You know, if you own a home here and in another country, the will here is going to certainly cover your assets that are here. And then in terms of whether or not the will also cover your assets there is something that I think there's going to be some differences country to country.
Yeah, I agree. And what about province to province? What if I'm a real estate investor and I own properties in Alberta, in Quebec, which I know Quebec is always very different with their laws and rules. So what is the dynamic there?
Yeah, so I can't really speak to Quebec because it is a different regime there. As far as the rest of the country, you wouldn't need wills in multiple provinces. So even if you own rental properties in other places, I mean, it can be a good idea just to um, speak to a lawyer there or do a little bit of research if you have stuff across the country. Yeah, I mean, it never hurts to do a little bit of research and get some answers about what that means for sure.
Okay, makes sense. So I know you already touched on children being, well, children and pets being an important part of someone's will. What if you don't have a will? What if a person doesn't have a will and they pass and they have no family in Canada? What usually happens? Because I feel like we don't really get to see or hear a lot of those cases. What happens? What if a person just passes and their child is there? What happens to them?
So it's a good question and it's a complicated question. So the we can sort of separate out again the distribution side of things and then the guardianship side of things. So if we start with the distribution, so what happens, and actually the executor piece too. So if you don't have a will, it means that you haven't named an executor, right? Which means that somebody, family, friend, someone needs to apply to be put into that role. And so if there isn't someone here in the country to apply for that role, that's very complicated. And I haven't seen how that plays out, but that would, yeah, it would be a real struggle because you would be sort of reliant on the province to step in to that role, which is certainly not ideal. Um, then with the distribution, if you have no relatives in the country, you're then also relying on the province to track down relatives in another country. Because if the distribution is happening according to the rules of the province, if there's no spouse and no kid, and then next in line is going to be siblings, you're relying on the province to go out and find your siblings to distribute assets to. Very complicated as well. And then when it comes to guardianship, it's a little bit similar in that someone needs to apply for that role. And if nobody does, then again, it's back into the hands of the province to make some determinations. And so without a will, you've not made any of those choices for yourself, and you're relying on the province.
Yeah, that's very deep to think about. And I think that everybody watching should really think about this, um, because again, just like Daniel said, the your will, a person's will is the only way that they can actually take control of what happens to their kids afterwards. So definitely don't want to leave anything up to the province when it comes to one's children, because a lot of things take time, processes and procedures, and so even before they find that sibling in a different country, I wonder how long that takes and where the child is going to be. So you definitely want to make it as simple as possible for your family members that you're, well, not you. One has to make it very easy and simple for their family members that they're leaving behind, so that it just doesn't become this big ball of complexity, and that is time consuming too, right? And it's a lot of running around too. So definitely do what you can to get your will in place and not have to leave it up to the province. Thank you for that, Daniel. Just before we move on, I wanted to mention I'm going to leave the link to Epilogue Wills in the description box of this video. And I have a coupon code, a discount code where it gives you dollars off. So definitely use that so that you can, it's already a very good price point, but that extra little discount is also nice to have. Okay. So before we move on to questions from the audience, because we have a few, what happens to a person's assets if they die without a will in Canada?
Yeah. So this has come up a little bit already, and so each province has rules about what happens if someone dies without a will, and it goes based on relationships. So if you're married with no kids, it will go to your spouse. If you're married with kids, there's a different distribution. Unmarried, no kids, it will start, with certain family relationships, and it will just sort of like continue. So
Okay.
without a will, you've given up that choice to decide who gets what.
What if a person doesn't have any family?
So, like at the very, very, very end of the chain, if there is no family, it goes to the province.
Okay,
I
that's what
think
I
the
wanted to
language
know.
actually says it goes all the way up to the crown.
Oh,
Yeah, if you get far enough in the chain. So,
and the crown is the federal government, right?
yeah,
Like the yeah.
yeah.
Yeah, that's what I wanted to know. Like, really, like, what if there's no traceability and no, family tree that is accessible, right? What happens? Okay,
Yeah.
so now, okay, good to know. All right, let's take some questions from the audience. If you have any questions, please drop them in the comment section and we will answer them. So Olu has a question. What should be included in the will? We already covered that, so we'll skip that for now. Okay, Olu has a great question. Is an executor the same as power of attorney?
So, no. So, there's the will, which is the document that speaks to what happens after someone passes away. And then there's two documents in Ontario. One is called a power of attorney for property, and one is a power of attorney for personal care. And in those documents, you set out who should make decisions on your behalf if you're alive, but incapable of making decisions. So they speak to two different time periods. So the will, only after you pass away is the executor going to start in that role, and a power of attorney, only if someone is alive but incapable of making decisions for themselves. So whether that's cognitive decline and they end up in a place where they're incapacitated, or if someone was in a coma, for example. So they can't make decisions for themselves. So the power of attorney is going to make decisions for that person during that period while they are alive, but incapable of making decisions.
Oh, great, thank you. And that kind of aligns with what I knew from the bank as well. Like when a client has a power of attorney and they pass, the power of attorney dies pretty much with them. And then moving forward, it's all about the will.
That's right.
So, Olu, I hope that clarifies your question. Thank you. And next, is it enough that a person has life insurance, and do they still need a will to ensure that the life insurance pays out to their beneficiaries?
So I'm going to sort of split that question into two. So the first question is around life insurance. So whether or not having life insurance means that you don't need to have a will. So they're different and separate. So life insurance is a payout that goes to your beneficiaries. So good to have, of course, but the life insurance doesn't do anything with respect to guardianship of minor children or pets. It doesn't name an executor. It doesn't set out what the distribution is outside of the life insurance policy. So it's not enough to have life insurance. The second part of the question, in terms of whether you need a will to make sure that the life insurance payout goes to the beneficiaries, the short answer is it depends. So if in the life insurance policy you name a beneficiary specifically, so let's say someone made had a life insurance policy and said 100% goes to John, you don't need a will for that payout to go to John. That will get paid out from the life insurance company directly to the person. Some people, when they do a life insurance policy, will name the estate. And so if you do that, it's not that you necessarily need a will for the payout to be made. The life insurance company has a responsibility to make the payout, but it will be much more complicated to get that payout in the hands of the beneficiaries. So part one is it's not enough just to have life insurance. The will is still very helpful for family, for friends, for everyone, making sure all of your wishes are carried out. Yeah.
That makes sense. You mentioned naming the estate for as a beneficiary for life insurance. So does that just mean that the life insurance payout now goes to whatever is listed in a will, or is that it? Did I hear that right?
Yeah, that's right. So, I mean, in terms of why someone would do that, there's some reasons to do it, and there's some reasons not to do it. So, one of the common reasons that people say not to do it is that if the life insurance policy goes through the will, meaning if you name the estate, then that amount is subject to probate fees. So about 1.5% of the value of that policy and 1.5% of the value of all of your assets are going to be paid in what's called the state administration tax. So that's one of the reasons why not to do it, why someone might say just name the beneficiary and have it go directly to them. One of the reasons why someone might want to do it is, let's say that your beneficiaries are minors. So someone has a life insurance policy and they've named 2 children to be the beneficiaries, and the children are 8 and 10. So that means that when those children turn 18, like the amount doesn't get paid out to them directly, but they will get all of it when they turn 18. So someone through their will might have a later age as the age of distribution for anyone who's under a certain age. So they might say, I don't want my children to get everything at 18. Let's make it 25. So in that case, if you had a life insurance policy and it was being distributed under the will, then the beneficiaries wouldn't just get everything at a certain age. It would wait until later. And also, whoever is the executor of your estate, the person that you've decided is responsible for that role, will also be responsible for managing the assets for the beneficiaries until that ultimate distribution. And so there's benefits to that as well. So there's not a clear-cut answer that applies to everybody, but a couple of reasons why someone wouldn't.
Okay, makes sense. And you mentioned the ages of children, and I'd like to kind of bring that up a little bit. What happens when you have minor children? When a person has minor children and they pass away, and the minor children are the beneficiaries of their properties in the will, what happens in that case?
So if someone has a will, so one of the questions that you would see if you went through and used the Epilogue platform is, at what age do you want any minor children to get control over their inheritance? So that's a decision that you can make when you make a will that says everything at 18, everything at 21, 25, 30, 35, 40. You can decide at what age children get full control over their inheritance. If you don't have a will at all, then it's the age of majority in the province. So as soon as they turn 18, they would get their entitlement.
And what happens if I state that I want my children to be 18 before they get anything, what happens to the estate in that period where where a person passes and
Yeah.
before the beneficiaries become adults.
Yeah. So the executor of your estate is responsible to create trusts under your estate for the benefit of each beneficiary. That's a minor. So if it was being split two ways between John and Sally and they're 10 and 8, and there's a total of $100,000 in the estate that's sort of left for distribution, the executor would put those into two trusts, 50,000 for John and 50,000 for Sally, and those would be invested. Like the executor would have a responsibility to manage that. And so maybe it's something that's very conservative, and it's in GICs until that child turns 18, and then whatever is in there at 18 will be distributed out. And then most of the time in the will too, the language will say that the executor has some discretion or ability to pay out amounts earlier than 18 if it's for health or education and things like that. So it's not that the money is necessarily stuck and you can't get any of it, but the age that you select is when they will get anything that's remaining.
Okay. A comment from Aramide saying that is looking real complicated. Well, not if one has a will, because that's the entire purpose, right? Having a will and being in control of those decisions so that you're not leaving it up to anybody else but yourself. Okay, we've talked about probate a couple of times during the session. What is probate?
So probate is the court process that a will goes through to be validated, where the court looks and says, this is the last will of this person, and it's the express permission for the executor to start acting. So it involves submitting the will to court. I mean, maybe I'll take one step back in terms of why probate is important. So if we look at the bank, for example, so an executor shows up to the bank with a will and says, this is Sean's last will. I'm the executor. Can we now move all of Sean's money out of the account and into a new account under the estate of Sean? And the bank needs to be sure that that is the last will. So it's not the case that 1 week later, someone else shows up with another will. So the way that the bank does that is by having, or not the way the bank does it, the way that the province does it is by having a process, a court process, where the will gets confirmed and validated. So that the bank knows that when someone shows up with the will that has that stamp on it, they can feel comfortable to take the next steps under the direction of the executor. The same is true in real estate, and there's other institutions where it's really important for them to see that there has been an approval process on the document. And when you go through that process, there's a fee that you pay, and it's approximately 1.5% of the value of all of the assets covered in the estate.
Right. And RBC helps with that if they're appointed as the executor of the will.
Yeah, so if they were the executor, they would participate in ensuring that probate was received.
Okay.
Yeah, so they would still help to manage the process of obtaining probate.
Okay, because I know that in itself can be a tedious process obtaining probate. Depending on the city that the person passes, but yeah, I've seen that sometimes some executors get tired even just trying to obtain probate and coming into the bank and trying to, but yeah, sometimes it's a process. So again, another reason why if you don't have somebody that you feel like you want to put that responsibility on here in Canada, RBC is there to help you act as that if you opt to. All right. A couple more questions that came in. Can the executor be a family member or does it have to be a professional? Atinika, we already touched on this a little bit. It can be your family member. It can be somebody that you trust. It doesn't even have to be somebody related to you, and it can also be a corporation that you appoint as the executor of the will. But again, we've been saying that being an executor can be quite tedious, and so that's why some people might opt to get professionals and know that this professional, like this corporation, is not dying, like they're not going to be indisposed, they're always going to be able to actually go through the process, right? So,
And then it's also just worth adding that even if someone names an individual to be the executor, that executor can get help from, for example, a professional trust company. So they do have services where even if they're not acting as executor, they can still help to support the executor.
gotcha. So, what happens when a person appoints an executor and it gets to that point where it's time to do the work and they just do not want to be involved in, maybe they never really were interested in being an executor of the will. Maybe after seeing all the responsibilities, it's just like, I can't do this. I'm not interested in doing it myself. I'm not interested in getting an organization to do it for me. Like, I don't want to be a part of it. What happens?
It depends. It's a difficult question. So in certain cases, they could choose to resign. Like they could never take on the role at all. And if there's an alternate who's named in the will, that person could step up and step into those shoes and take on the role. If there is nobody at all and this person just doesn't do it, someone else could apply to the court to be put into that role and to be named as executor. There could be the opportunity for that person to speak to a professional trust company and see if they could do a complete handoff where that trust company takes over the role as executor. So there are some options, and it really depends on the circumstances.
Okay, interesting. Thank you. Another question from Olu, and she says, "Can I update my will as my life situation changes? For example, if I buy another property, can I change my will?"
Yeah, absolutely. So I think it's a misconception out there that someone should only make one will, that you sort of wait until your family looks the way it's going to look, and then you make one will and it's your perfect will and you never change it. So that's not realistic given how much life changes. So yes, you absolutely can change it. You should change it. When someone has more kids, for example, it's a good time to go back and look. If you receive an inheritance, if someone else passes away and you now have more money, it's another time to go and look and say, are my wishes the same? Is my distribution the same? If someone who's named in your will, if something should happen to them, if they should pass away, if the person who you named as executor isn't around anymore, it's a time for someone to look and say, okay, I need to update my will and name a new executor or a new guardian, or even someone who makes a will when kids are young, who chooses a guardian that they think would be the right person for the job. That might be different in 10 years. It might be that someone who is the right person to look after a 3-year-old is not the right person to look after a 13-year-old. So your will is a document that you should be comfortable changing. With Epilogue, if you've created your will with us, you can make changes for free. It's unlimited updates anytime. So you could come back in 2 years and make a change, or 5 years, whatever it was. And if you've done your will with a lawyer, you can certainly go back to them and make changes there as well.
That's absolutely awesome because it's easy for you to just, charge a little fee for each update. But wow, yeah, that's awesome. Free, unlimited updates, people.
Yeah.
That's awesome. I like it. Do we have any other questions from the audience before we let Daniel go? Or Daniel, was there anything else that you wanted to touch on that maybe I didn't ask?
Just that if you go to the website and look around a little bit, we've got a blog, we've got a Learn Center. So there's a lot of information in there about the different roles, about executors and guardians, about distribution. Yeah, lots of content there. So feel free to go take a look. If anyone has any questions, you can reach out. We've got a live chat feature on the website, or email addresses that'll come to me, and we're happy to help.
Awesome. That's good. And I've been scrolling through those blog posts. Very, very insightful. So thank you for having that content available free of charge. Fisaya is asking, when is the ideal age for someone to have a will?
So I won't necessarily speak about the ideal age, but a time when many people will start thinking about making a will or make the first will. So when you get married, when you have kids, when you buy property, those are times where it's really common, so that you make sure you name a guardian. Even if pets, and really for anyone who's got money in the bank, if you want that money to be accessible, having a will, naming an executor, someone who's going to be responsible for getting probate, making sure that that money can be distributed. So there is no ideal age, but it's probably younger than most people think it is when they should start thinking about getting their first will done.
Okay, awesome. And Marina just joined. Hi, Marina. And she's asking if we've talked about what happens when a person passes interstate in Canada.
Yeah, so we did a little bit. If you die intestate, that's just the legal term of meaning dying without a will. And so ultimately, when it comes to the distribution of your assets, it'll be based on the rules of the province where you live. So who gets what? You will have not named an executor to be in charge of everything. You will have not named guardians. And so lots of different consequences of not having a will.
Yes, and we've touched on those consequences a bit earlier on in the video. This video is going to be up on my YouTube channel. You can always go back and rewatch, and you can share with your family and friends to make sure that they are actually in control of their final wishes. That is very important, obviously, from the entire conversation today. If you haven't taken anything away, one thing you should take away is you don't want, to not be in charge of your final wishes, what happens to your properties, your family, your pets, which I didn't really think about before. But yeah, you want to make sure that you're in charge of those wishes after one passes. But yeah, thank you very much, Daniel, for joining us today. I think it's been 47 minutes. I'm going to let you go. Thank you so much for joining us and taking time out to, kind of lecture us on Epilogue. And even thank you for building such a platform that allows people to create basic wills at such an amazing price point. So yeah, thank you. Lots of thank yous in the audience as well. So yeah, thank you.
Absolutely. And thank you. Thank you for helping to sort of bring this message to your audience. Thank you so much.
Yeah, it's my pleasure. It's what I do. So yeah, again, I'll have the link to Epilogue Wills in my description box of this video and probably in the pinned comment as well. And I'm gonna put my discount code on there for you to be able to get a discount when you're setting up your will with Epilogue Wills. Okay? Thanks everyone for joining and have a great rest of your weekend. Bye.
Thank you.